You're on.
Thank you, Mr. Chairman. Members of the board, I'll be very brief. You have Exhibit D in your packet as information regarding the updated latest information about Lexington High School and the wetlands. And with that, I'll conclude my brief
Presentation. You asked me earlier, Mr. Chairman, I have a motion I want to make for the executive committee for our next meeting. It has nothing to do with the presentation I just made, but it's in regards to the changes that occurred in our budget we approved in June. I want to give you and your staff an opportunity to prepare for that. In June, we approved the budget around these figures, 138 million. We're now operating with a budget of 142. I know a lot of that had to do with the step increase, but I would appreciate the executive committee adding to the agenda next month or next meeting an opportunity to go over that budget to discuss those changes so that we have a full understanding of the differential. You have written that motion. The motion is I'd like to make the following motion: the executive committee, including our next board meeting agenda, thorough discussion of the changes that have taken place in the budget total that were approved June 13, 2011. And I just think that we really probably need a motion that you'll give us that. And then what I'd like to do is as a board, you can just work through this and ask about working through the funding and what we're going to have at that time. See, you don't have to answer that now.
we will be doing a monthly financial report for the month at the
Next meeting. That's when you're asking.
Right, I think if we can include it in that report. Thank you.
Just again, I'd like to make a brief statement about our financial situation.
Yes, sir, you are.
At Chapin High School, and read a brief statement on the record as we're allowed to do for purposes of minutes, and then I have a motion to make after that. It relates to, Carl, the cost here, and what I see as a very significant policy issue. And I just want to tell you, you've created this memo, this report at my request some time ago, and you've got a number at $1.8 million is the approximate cost that relates of Chapin High School costs this district. And I'm going to read a higher number, but my statement is self-explanatory, and then I've got a policy statement. I'm going to read this in accordance with our procedures, and I'm going to try to get quickly to verbatim so there's no issue there.
You have copies of
Yeah, you want me to read it first? Or go ahead.
You can read it. I just want to make sure that the styles will have it. And yes, go ahead.
Yeah, I'll read it and I'll pass the board to them. I'll follow the motion. The caption is on the record statement submitted by Ed White, September 12, 2011. Ken Murphy versus South Carolina Department of Health and Environmental Control in District 5 of Lexington and Richland counties. Number one, the damage as a result of the legal proceedings filed by Mrs. Murphy for the Chapin High School project is now approximately $7,638,655. This amount includes the actual expenditures from legal and consulting fees, the estimated increase in construction costs based on current bid prices, and the increased interest cost of the 20-year life of bonds. Because we are in a near zero interest rate environment, $7,638,655 amount of estimated damages today approximates the present value of payments over the 20-year life of bonds that will be issued to fund the project. A complete transcript of the 10-day trial and the court's order is posted on the District 5 website. And I would encourage anyone trying to understand why we incur these expenses to read the transcript of the trial and the court order. Number two, I would like to recognize the extraordinary ruling that Maggie Stroud and the group D5 citizens ensured the implementation of the referendum, Inc. obtained from our state court that keeps Mrs. Murphy from filing additional legal proceedings against District 5 construction projects. This court order has a profound significance not only for District 5, but for all school districts throughout the state. A copy of the temporary restraining order against defendant Murphy is attached, and I'm requesting that the district post a copy of the temporary restraining order on the District 5 website. I would like to personally thank Maggie Stroud and And the D5 citizens ensured the implementation of the referendum because they took the initiative to raise private funds, to hire an attorney, and press for this court order to help District 5. It is a tremendous ruling of profound significance for District 5, as well as for all school districts in the state. Number 3, I see a very important policy consideration in this temporary restraining order. The policy concerns is, as a school district, we do not have an effective legal remedy against a fellow board member who institutes legal proceedings to challenge a decision or action of this board when the challenge causes economic damage to the district. The reason we do not have an effective legal remedy is that a school board member has immunity from legal liability for anything they do in their role as a board member. Any decision by a school board to seek a legal remedy against a fellow board member is complicated by the reality it would have to prove the board member was acting outside the scope of their authority or role as a board member. As a practical matter, any lawyer defending a school board member would argue the person's actions were within the scope of their role as a board member. It could be difficult for a court to make a factual conclusion that their actions were completely outside the scope of their role as a board member, and a court would probably favor protecting the board member's immunity. Number 4, the practical reality is that it's too easy for a political group to marshal their resources behind a board member and let the board member bring the legal proceeding to challenge the district's actions in the board member's name and have a shield of immunity for all their actions. This means that a political group could conspire, engage in misrepresentations, and abuse the legal process for an improper motive and be shielded by liability by simply hiding behind the name of the board member who brought the action. In contrast, if private citizens file a legal proceeding to challenge the school district's actions for improper motives, conspire to misrepresent facts to abuse the legal process, and cause the district economic damage in doing so, the district can pursue legal remedies in the court system and seek compensation for the damages caused without the shield of the board member's immunity from liability. In other words, if private citizens bring abusive legal proceedings against the school district, they face the risk that they could be personally liable for the economic damages they cause. Number 6, I would like to publicly encourage Maggie Stroud and D5 citizens ensuring the implementation of the referendum to press ahead in the court system to seek a permanent order against Mrs. Murphy to restrain her from bringing further legal proceedings in her name to block District 5 construction projects. Number 7, I know Maggie Stroud and D5 citizens ensuring the implementation of the referendum is raising private funds to continue the legal process to acquire the permanent order. And I want to thank you for your efforts. Number 8, I believe as a board member we should adopt a resolution of the trustees of District 5 that A, we send a letter to the South Carolina School Board Association to ask it to review the temporary restraining order against defendant Murphy and consider assisting Maggie Stroud and the D5 citizens ensuring the implementation of the referendum with this important policy decision pending before our court system. B, we ask the South Carolina School Board Association to consider sponsoring legislation that prohibits a school board member from instituting any legal or administrative proceeding before any court or governmental agency to oppose a school board action. And C, we write a letter to the entire legislative delegation representing District 5, asking them to review the temporary restraining order against defendant Murphy and consider adopting legislation to the same effect. And I now have a motion I'd like to make and read. Go. And I have a copy for civil. And I got a copy of the order as well. Motion that the board adopt following 4 resolutions in a singular motion. Resolved that the Board of Trustees of District 5 of Lexington and Richland counties hereby request that the South Carolina School Board Association consider sponsoring legislation that would prohibit a school board member from instituting any legal proceedings or administrative action before any governmental agency or court to oppose any action undertaken by the school board on which the member has a seat, and that the South Carolina School Board Association allow the chairman of the District 5 board to present this request as a formal proposal for a legislative initiative at the School Board Association's December 2011 meeting. Resolved that the Board of Trustees of District 5 of Lexington and Richland counties hereby request that each member of our legislative delegation consider sponsoring legislation that would prohibit a school board member from instituting any legal proceeding or administrative action before any governmental agency or court to oppose any action undertaken by the school board on which the member has a seat. Resolved that the Board of Trustees of District 5 and Lexington and Richland counties hereby request, I'm pause again, it's after the board, so they're going to have to look at this. I'm going to start that one over again. Resolved that the Board of Trustees of District 5 of Lexington and Richland counties hereby request that the South Carolina School Board Association review the temporary restraining order against defendant Murphy obtained by Maggie Stroud and the D5 citizens ensuring the implementation of the referendum Inc. and consider providing assistance to Maggie Stroud and the D5 citizens ensuring the implementation of the referendum Inc. with this important policy issue before the court that affects every school district in the state. Resolve further that the chairman be authorized to write letters to the South Carolina School Board Association and the legislative delegation representing District 5, communicating these resolutions and requests to be submitted on behalf of the board, include a copy for their review of the temporary restraining order against defendant Murphy.
This is your motion?
Correct.
You all heard the statement and the motion. Have a second?
I second it.
Watson, second. Why don't we go back and use for discussion, very briefly? You have a lot of things that you could do this background.
These are, this is what I view as a very substantial policy consideration. This is an effort to ask for help beyond this board, beyond this community. I really believe that this is an extraordinarily important ruling, and we are simply making requests. I think time is very important because my understanding of the legal process is they have a temporary restraining order. This group has to go to trial to seek a permanent order, and I'm assuming it's going to be set very soon. So I think it's imperative that we move quickly and make this communication and ask the School Board Association to look into the case and see if they will offer any assistance. It could be a policy statement or some other assistance. But then we also proceed with these legislative initiatives.
Clarification here. I certainly support moving on, and I'd like to know how many resolutions Ms. Stowers might know. How many times I think we have voted in the 6-1 vote that we resolved this should get moved on. I support that. The only part of this that, you know, this first time I've seen this, and the only thing, and it's not personally Kim Murphy, but in my mind, a temporary restraining order against any person that wants to bring a suit. You know, I'd like to resolve this problem. I'd like to hope Ms. Murphy would drop the suit in one of those unsuspecting individuals we heard laid out tonight. So I just don't know how far something like us, you know, trying to stop as a board, another board member, even though I don't approve of this, I guess as a government teacher, you know, I don't know that if we start a precedent that we try to have a restraining order against anyone trying to have some type of suit in the future that may have merit, even though this doesn't. You know, I don't know if I made myself clear. I just don't know if this is the kind of thing we as a board should do. I might hope Ms. Murphy might just drop this thing. We don't have to worry about it finishing.
If I could offer a clarification, I think I could clarify what my objective is. This has nothing to do with Ms. Murphy other than the fact that there's a case that she's a party to that we're asking the school board to talk to the people that brought that. We didn't bring that suit. So this is really asking the School Board Association to come in and get involved in our community. But the policy consideration applies to anybody on this board, any future member of this board, and it would apply across the state for every single school district. So if you sit on a board, you shouldn't be bringing any action in a court or governmental agency to oppose the decision of the board where you participate in that decision. Any member of the public can bring that action. The difference is a member of the public has certain standards they have to abide by when they vote for legal procedures. And if they want to